my learned senior, Maretta Briopon, when John Dramani Mahama was president, is the one that gives a 42-day timeline, not 90 days. Now, when you go to the second schedule of CI 99, and I want to encourage you, our colleagues in the media, to just find it and publish it. Filing and service is on day 1. And in practice, in accordance with CI 99, you have up to 21 days to file the petition. But the moment you file the petition, day 1 starts counting. It's not the number of days that you are sitting in the court. Because if that would be the interpretation, it cannot start counting from day 1 because the court would not have even empaneled by then. Then by the 7th day, it is expected that appearance and answer would have been entered. This petition was filed on the 30th of December. Even if you said by the 1st of January or 31st, what it means is that by the 7th or getting close to the 10th, appearance and answer should have been entered. By the 10th day, it is expected that pre-trial will commence. And pre-trial, which combines a number of things, case management, memorandum of issues, orders and further orders, are expected to take about 5 days. This is how come my learned senior, Dominic Ayene, was talking about 5 days, 5 days, 5 days. Because CI 99 gives you pre-trial starting at 10th, and by the 15th day, hearing is supposed to be occasioned. Then by the 21st day, between the 15th and the 21st day, hearing is supposed to have ended. You can calculate the number of days yourself. And then by the 42nd day, judgment. If you do the calculation, it's somewhere around the 19th of February. If you deliberately end, it is around the middle of February because for the presidential election petition, weekends, public holidays all count. Weekends and public holidays all count. We didn't pass this law, they did. But even if you choose to add or take out weekends and public holidays, that's how come you end in the first week in March. So anybody going around saying that it's 90 days, with the greatest of respect, is not reading the law. Now this afternoon, you have heard colleagues from the other side refuse to speak first to the issues in court, and then now raise objection with our use of the word theatrics. Yes. We are of the respectful view that what they are doing, as has been said by some, is 15% law, 85% propaganda. Because what they are doing is that they are refusing to follow the rules that they themselves even supervised and the orders of the court. As has been mentioned, the rules of court are quite clear. When a district court in Ofuase gives an order, not a suggestion, not a question of counsel, an order from a district court, you don't violate it that you are counsel and you think otherwise. The Supreme Court of the Republic of Ghana gave all of us orders on the 20th that we should file statements. Why? Because the court has been invoked and now is seized with issues. And the petitioner has to file his witness statements so that the court will now look at those witness statements, compare that to the witness statements of the respondents, and then we begin to proceed. The one who was to ensure that the court is seized with the witness statements refused to do his.
No, well, so the word refuse may be too strong because we heard Mr. Chachuchikata say in court that they did not file because they had already made an application for a stay of proceedings. And based on that, they did not file, not because they wanted to disrespect the court.
Every lawyer knows that when the court gives an order, it is not within your bosom to explain that I think that because of X or Y or Z, I ought not to comply with the order. Every lawyer knows that. And that is why the bench asked them that while you refuse to file those processes, you still filed other processes. Are you saying that those other processes are not connected? You want us to follow the processes you are filing, but the order of the Supreme Court of Ghana you don't want to follow. Assuming without admitting that this court comes to the view that there was no winner and orders that there should be a rerun of the election, you expect the EC to follow? Or the EC and its lawyers should also explain that they are of the view that this is an order of the Supreme Court of the Republic of Ghana. And you saw them today in court. First of all, Mr. Chikata was not in court early enough. His colleague, Mr. Letha, was in court and speaking on his behalf. Then he comes in, by which time they've made those arguments that they were under the impression that their application for stay of proceedings, what is it? It's a superior application to the order of the Supreme Court. Colleagues, you are beginning to see what we have been talking about, that there are efforts to put impediments in the way of this trial. Now, finally, the court, we think, has been overly magnanimous, overly indulgent, because ordinarily the rules are clear. If you do this in the district court, they'll strike out your matter. In the high court, they'll strike out your matter. And today the court was pleased to read the rules one more time to learned counsel. They usually don't do that. Those of you who cover courts, they usually don't do this. The court has read the rules that when you file a petition and the court gives orders that bring your witness statement, you know that even if some interlocutory matter becomes relevant, you can always come by supplementary to add it. But you are deliberately pretending that until your review or your stay is granted, you are stopped from going ahead. No problem. But the court today has been overly magnanimous in making the point that if you don't do it, the rules of court are clear, that they will strike out your petition. I mean, I think, for example, supporters of the NDC should be talking to their lawyers and their petitioner by now, because what is happening is that they have told them one thing in the public domain, that they have won this election. Then they have come to court to say they didn't win and Anadu didn't win. Now the court says, come and prove it. We are ready to prove it. And you have seen the theatrics. And we are very, very respectfully of the view that what they are doing is theatrics. 85% propaganda, 15% law. But we are in the hands of the court, and we look forward to what will be decided in the end.
All right. Thank you very much, Honorable. We are very grateful for your time.